Good morning, ma'am. Yes, and honourable members, the agenda will come up immediately. Thanks. There we go.
Thank you very much, Haran. Can we have a mover for the adoption of the agenda? Honourable members, the agenda have been circulated for quite some time. So in this meeting, we are not making any additions. We deal with the agenda as is, because if we haven't received anything that is referred to this committee by the speaker, other than what is on this agenda. So is there a mover for the adoption of the agenda, honourable members?
Chairperson.
Honourable Singh.
Yeah, thank you. Thank you very much. I suppose that we will consider the draft minutes and matters arising. I really thought the agenda was going to be dealing with all the matters. The Parliamentary Budget Office report, etc., etc. Will that arise? Or am I looking at the wrong agenda?
Aaron?
Thank you, Chair. Yes, Mr. Singh, all those items are in fact fall under item 4. So the issue of the PBO, for example, will be attached to item 4. So everything else will be fall under that item. Thanks.
Okay, thank you, Chair. Better if we list it next time. Yeah, Chair, I've got a problem that at 10 to 11 I have to leave. Unfortunately, I've got a site in local inspection meeting with ESCOM, and I hope that we are done by that time.
Thank you, Honourable Singh. Your apology is noted. Is there a mover for the adoption of the agenda, honourable members?
Yes, Honourable Chair. Oh, okay. I second, Chair. Thank you very much.
Honourable Singh moves, Honourable Lisoma seconds. Thank you very much. The agenda is adopted and seconded. Can we now consider the minutes of the 21st of October 2022? Perrin, may you please flight the minutes on the screen?
Yes, ma'am. I see that Honourable Papo has his hand up though. I don't know if you want to take his hand up.
Okay, my apologies, Honourable Papo. I didn't see your hand. You may take the floor.
I think we forgot the apologies, the item of apologies, because it's the first item, because otherwise we will mark people absent without considering the item.
Thank you very much, Honourable Papo, for bringing that up. You know, when you are from another meeting, then you think that it's a continuation of the meeting, but it's not the same meeting. Thank you very much, Honourable Papo, for bringing that up. Perrin, do we have apologies for the meeting?
Yes, ma'am. We have one apology from Dr. Kornhoff. I just wanted to indicate that he's actually not formally a member of the subcommittee, but he does attend whenever he can because there is business sometimes that involves his duties. Thanks.
We have an apology of Dr. Kornhoff, who's always attending the subcommittee meeting, even though he's not a member. But we know that our rules allows for that. Then do we have other apologies, honourable members? Honourable Papo?
Hey, I wanted to indicate that I had planned to attend the whole meeting, but at 12:30, if we have not yet, because the meeting is budgeted until 1. So that's what I had planned for. But at 12:30, I need to leave to go to the airport to catch a flight to Mthatha to attend the funeral of one of our employees. There's only one flight. If I miss that one, I won't catch it today.
Your apology is noted, Honourable Papo. Are there other apologies, honourable members, other than the 2 apologies that we have received? No apologies at all. So it means the other members will be joining us. Can we now move on to the minutes? Haran?
Ma'am, the minutes should be on the screen. I hope I can see them.
Yes. Let's move.
Could you, thank you, thanks. That's moving up.
We're dealing with corrections of the minutes. Page 1. Let's move to page 2. The minutes were circulated as well to all of us to allow us the opportunity to read and correct where we need to correct. Let's move. Page 2. Let's move to page 3. Page 4. Page 5. Page 6. Page 7. Page 8. Page 9. Thank you very much, Perrin.
Thank you, ma'am.
I don't see any hands. Oh, Honorable Papo? Honorable Papo? Your hand is up.
Mr. Singh's hand is also up, ma'am.
Honorable Singh?
Chairperson, I move for the adoption of the minutes. Thank you. I didn't see anything that needs to be corrected. Thank you.
Thank you very much. Honorable Janji, RD?
I support and second the adoption of the minutes.
Thank you very much, Honorable RD. Let's now move to matters arising from the minutes. Mr. Kaso?
Thank you, Madam Chair. Just to assist the meeting, to indicate that the issues raised regarding rules that had to be amended or guidelines that had to be clarified have since served before the Rules Committee. That would relate to the issue of backgrounds on the virtual platform. That matter served before the Rules Committee. The matter of delayed replies to questions. That matter has since served before the Rules Committee. And a process was agreed to, and as well as the issue of interpellations, and the view was that the matter should the current process should just be improved, but interpellations would not be reintroduced at this point. And there was the issue of placards as well, and that rule amendment served before the Rules Committee. And the matter was clarified there and agreed to. The issue that still is serving before this subcommittee relates to a committee on oversight committee on the presidency, which is one of the matters on the agenda of today's meeting. Thank you, Madam Chair.
Thank you very much, Mr. Kaso, for that clarification. We are not going to deal with those items that were dealt with and we agreed upon in the Rules Committee, as you have alluded to. Thank you very much for reminding us. So, honorable members, Mr. Kaso, who's going to take us through the presentation? Honorable Soma, I see your hand.
Thank you very much, Chair. I think probably for my participation, if I can request through your permission that can I be included in the mailing list so that until further notice, that will assist me as well. Thanks, Chair.
Okay, Honorable Soma, that will be done. Mr. Kaso.
Thank you so much. Ma'am, Perrin will take the committee through the presentation. We also just want to highlight that we've got the budget office who will speak on the issue of the work they were required to do on the issue of the presidency. The research office is also on standby in case we need to ask questions of clarity regarding the research that they have done. But Parent will take the committee through the process, and if I need to come in, I will. Thank you, ma'am.
Thank you, Mr. Paso. Parent?
Yes, thank you, ma'am. Thank you again, ma'am, and honorable members. This is the presentation I'll be giving today. It's based or derived from the discussion document, which was circulated as well on the recommendations from the Judicial Commission of Inquiry into State Capture and the implications for parliamentary procedure. So the discussion document was circulated previously. Members will recall that at the last meeting of the Rules Committee, the Rules Committee decided to refer those recommendations from the State Capture Commission, which related to procedure, to the subcommittee. In addition, the Speaker received correspondence from Mr. Singh, Mr. Shivambu, and Mr. Singula, which concerned one of the issues on the agenda, that being the possible creation of a committee to oversee the presidency. In addition, Parliament's Research Services, and Mr. Kasu has referred to this, and the PBO compiled research on certain topics. These documents and research papers were also circulated. What I propose, I think Mr. Kasu has also mentioned this, is I'll take members through my presentation, and at the end, if the Parliamentary Budget Office could they have a presentation on item 7 there, which is oversight of the presidency. That's the research they were asked to develop. So I'll introduce all these matters, and then if we, Chair, with your permission, if we could then go to the PBO. Chair, I think, sorry, if we could just move to the next slide. I think in order to contextualize the recommendations of the Commission, we thought it would be prudent to provide a few comments on the evolution of parliamentary oversight. This is useful because some of the observations made by the Commission are not new. And in some cases, progress has already been made in respect of certain issues, and I'll touch on this as we go forward. In this regard, members will recall that in 1999, I think it was, after the beginning of the second Parliament began to look quite closely at its oversight role and the practices at the time. And then to enable this shift, Parliament asked for research to be done by Professor Corder from the University of Cape Town. And after that, after detailed discussions then at the time, the Parliament adopted the oversight and accountability model. This was, as I said, around about 1999 or just after. Now, the Corder report promoted, amongst other issues, the concept of what he called a mandatory accountability, which is a notion that where deficiencies have been uncovered by parliamentary committees or by members, that the oversight that leads from that must result in that those deficiencies be corrected by the executive.
Parent?
Yes.
Just a minute. Apologies, Chair. I'm going to request the colleagues who are handling the slides to please move with the presentation. Thank you.
Thank you, sir. Yes. The other interesting concept which Professor Corder raised in his report was the idea of an Accountability Standards Act. And the intention of this act was, in his view, to further define Parliament's oversight role and powers. And I raised these issues because the Commission also touched on them. In fact, I think it would have had sight of the Corder report. And so these things will, in a sense, also come back to us. I'm going to just quickly move across the slide and maybe go to the next slide just for brevity's sake. So I want to now turn to Sorry, yes. What's this?
Chair, yeah. Chair, may I come in?
Honorable Singh.
Yeah. Thank you very much. Sorry to intervene. And I'm glad that Mr. Handick said for brevity's sake, because I think what we are receiving now are things that we've been through before. The minutes said that we needed a report from the PBO to amplify, and I just wanted to correct Mr. Handick in the beginning for the records that, he said they received a letter from, he mentioned 3 people. But just to say that this matter has been on our agenda for some time now, for more than a year, and those letters were only received now in February. So I think that needs to be recorded. Thank you.
Honorable Singh, I think what he's dealing with now is dealing with the recommendations from the Judicial Commission of Inquiry. That is what I understand him to be dealing with, those recommendations. Then the issue of the letters, the matter of the Oversight Committee is before this committee. It was brought by yourselves. So the other two letters came after, that one of the ATM and the EFF. My understanding is that we deal with the recommendation of the Judicial Commission of Inquiry. Then after that, the PBO will come in. I know you are in a hurry, but let's start there, then we'll come to the PBO issue.
No, okay, Chair. So we are dealing with item 4 then on the agenda. Thank you.
You may proceed, Parent.
Thank you, Chair. Yes, thanks for the clarification. I will try to be as brief as possible. So I just wanted to now turn to the recommendations of the Commission, which are actually located in Report 6, Volume 2, pages 463 to 465 of the Commission's report, which was the last report that they issued. So in summary, the recommendations that they made relate to the following areas of procedure. The first is House resolutions, which emanate from oversight activities, executive reports and submissions to Parliament, executive attendance in Parliament, and if you could go to the next slide, the selection of office bearers in state institutions and how Parliament manages those processes, the establishment of an oversight committee of the presidency, which is what Mr. Singh was referring to, as well as the practices and rules associated with the committee of chairpersons. So those are basically in summary the issues that the Commission focused on, and this the report that we produced as well as the presentation will touch on each of these, and then at the end we will again get a more detailed presentation on the oversight committee of the presidency. So I do also need to indicate that the Commission suggested that a number of these topics could or should be provided for in law and or Parliament's rules. In other words, they were considering the possibility of what Professor Corder called an Accountability Standards Act. Now, the question of legislative change may finally belong with the Joint Rules Committee, and this is because any act of this kind, Accountability Standards Act, if you were to call it that, would involve both houses. Oversight and accountability, obviously the function of both houses. And so it would fall somewhat out of the ambit or the remit, if you like, of this committee, the subcommittee, but it's something which the Rules Committee could then take forward through the Joint Rules Committee. But that's also not to say that that rules couldn't be developed in the interim, because an act obviously follows a particular process and can take some time. So there's nothing preventing the National Assembly or Parliament from developing rules to close some of these gaps, even without a statute. Could you perhaps go to the next slide, please? This is what we've just kind of distilled what some of the concepts that such an act could include. And again, this is a matter maybe for the Rules Committee at this point, but it would deal, maybe it could deal with the definitions of oversight and accountability, the oversight mandate of each House of Parliament. And again, the court report and in fact, the oversight model did capture some of these ideas. Minimum standards of executive accountability, reporting obligations and remedial actions, executive attendance in Parliament, and what could then be provided for in the rules. So as I said, such an act would not necessarily prevent, we could look at rules in the interim without necessarily having an act of this kind in place. So what I wanted then to turn to was the first subject raised by the Commission, which is to do with House resolutions emanating from oversight activities. I do wish to say that that the Commission distinguished between the ideas or subjects, I should say, of parliamentary resolutions and executive reporting. But in our view, the two are very closely linked, and so in fact we've combined them in our paper. Many, or some, I should say, executive reports emanate from legislation, such as annual reports and the budget review reports and many others, but many are also made in response to House resolutions. So members will know that many committee reports, for example, that are issued after their oversight work call on the executive or departments to supply Parliament with more information or to account for certain actions that they wanted to see happen. And the Commission in the Commission's view, there was a sense that the executive has not always taken account of parliamentary resolutions and reported thereon. And this was the reason that they recommended that Parliament take steps to address this. So again, I try to be brief. As a point of departure, it must be said that some challenges with the implementation or otherwise of resolutions have their origin within Parliament, not only with monitoring, but with the technical nature of decisions themselves. So reforms to improve executive responses or remedial actions would also have to, in our view, include some rules or guidelines, if you like, to do with the nature of parliamentary resolutions themselves. And one of the points we've made there that recommendations must be substantiated and specific. So where committees recommended that a government produce a report, they must include, for example, timeframes. Otherwise, it's very difficult for the executive to comply because they wouldn't necessarily know by when or what kind of information they should solicit. So that's the first point. The second is, and this is done to some extent already, but not formalized, is that the Speaker must maintain a record of resolutions that have been adopted by the House and sent to the executive, and liaise with the LGB, the Leader of Government Business, if there are delays. And as a last resort, legal actions could be considered. And that's something else that the Accountability Standard Act could perhaps deal with. We also suggest that at the end of every year, or at a certain time every year, the Speaker must report to the Rules Committee on the status of responses. We're talking now about executive responses. This is quite similar to what the Speaker is doing currently to do with questions, unanswered questions to the executive. So this would not be a new idea, but now the Speaker would also speak about, with the input, obviously, of the government, what is the status of parliamentary resolutions. The opposite side of that is rules to do with what is expected of the executive. So the executive should report to Parliament on issues emanating from resolutions within the timeframes prescribed, or in the event of no timeframe, 60 days. This is an option. It could be less, it could perhaps be more. Then in the event of a delay, a minister must inform the Speaker of the reasons for the delay and provide a reasonable time frame within which a full report can be provided. And then the last point there is that the Leader of Government Business must submit an annual report to the Speaker on the status of executive compliance with the resolutions for inclusion in the Speaker's report to the Rules Committee. So then that links up with what I was speaking to earlier. So then just to step off, so let me say maybe at this point that these are the sort of steps we are proposing, and there are steps in respect of each of these recommendations. What we then propose at the end would be that if the subcommittee and the Rules Committee, of course, agree with the direction that's been taken, then the subcommittee would then go back and draft specific rules. So at the moment, we're setting out a possible way forward based on what the Commission has suggested. But these would be decisions which then would have to be taken, and then we could revert back with technical change or technical drafts, basically, of the rules of each of the subjects. I'd like to turn now to the second issue, which has got to do with executive attendance in Parliament. And now they raise this again as a possible concern, particularly in the context of committees. Now, our view was that the Constitution and the rules do envisage, of course, that ministers and deputy ministers should, as part of their duties, attend Parliament and committees when required. Now, because of the perception by the Commission that this didn't always happen, the Commission then recommended that a non-attendance there should be sanctions for such occurrences. Now, in terms of compelling attendance, I must say that the Powers and Privileges Act already makes an offence for any person, including a minister, to refuse a summons or to give misleading evidence, etc., to Parliament, such actions being considered contempt of Parliament. So there's already a legislative sanction that can be imposed if anyone, to include a minister, refuses to come to Parliament. But it should be noted that invoking the Powers and Privileges Act, and this is in the context of cooperative government, has always been considered a means of last resort. And it is preferable that Parliament and the executive cooperate before such a sanction is pursued. Obviously, activating the Powers and Privileges Committee and such a process also takes a long time, and it wouldn't always assist, because if a committee needs information now, it's not very much use if it only gets that information in a year's time or 6 months' time. So we are proposing that there should be perhaps an intermediary step, which could, for example, involve the Speaker and the Leader of Government Business. In other words, if a committee or if a minister doesn't attend a committee when a committee is asked for such attendance, then the committee should raise that with the Speaker, who would then take that to the Leader of Government Business to seek an intervention. So if the members feel that there is a need for such an intermediary step, then again we could draft rules to accommodate that. Then to turn to the recommendations about the appointment of office bearers in state entities. So this would include Chapter 9 institutions. It would include a whole range of other organizations and entities and institutions which created, some of them by statute. Now, the Assembly plays a role in the selection of these office bearers. In most cases, based on correspondence, which alerts the House to a vacancy, and it often comes from the Presidency. The relevant committees consider and select candidates to be recommended for appointment in accordance with the law. So in many, each law has its own requirements. Now, while these processes are, and this is in our view, for the most part, transparent and systematic, there have been questions concerning best practice, as well as the standardization of practices across different committees. Now, the Commission accepted the observations that candidates for office must be subjected to a high level of public scrutiny and must be appointed on the basis of merit. And the then Commission endorsed some of the recommendations that emanated, I think, from, it was a non-government organization, Corruption Watch, I think it was, that legislation should be developed on the basis of these principles to clarify how appointments are made. So without going through there to each of these, if you could go to the next slide, I again wanted to say that the question of legislative review of this kind would again fall outside of the immediate scope of the subcommittee. But the rules could, of course, provide guidance to support these processes. Sorry, could you just go to the next slide? Apologies, am I still audible?
Yes, you are.
But the presentation is not
moving, yes. I'm just sorry, ma'am, if I could just take a minute to see what's becoming of the presentation. Thanks. Thank you. Yes, I can see the presentation again. If we can go to the page I was on, there, yes. So I was saying that the question of legislative review would fall outside of the immediate scope of the subcommittee. Again, that's something that could be initiated from the Rules Committee or the Joint Rules Committee. And it would perhaps ultimately involve a subcommittee of some kind to work in each of these areas in each of the various sectors to see how they could standardize practices. But the rules could provide guidance, and what we've then recommended some basic principles. So in other words, a committee that's seeking to select a candidate would have to advertise for applications and provide at least 2 weeks in which to apply. It would publish any shortlist, as well as the qualifications of those shortlisted before any of those shortlisted may be interviewed by a committee, and invite the public to make written comments within this time. This was something that the Commission spoke quite a lot about, in a sense, focused on, that the concept of public involvement should also actually apply to this process. In other words, once candidates have been identified, the public should be allowed an opportunity to raise or to bring matters relating to those candidates to the attention of the committee. So in their view, this would increase the transparency, if you like, of the process and the levels of public involvement. If we could just move to the next slide quickly. Yes, so also what we suggest is that when a committee makes a report to the House after having conducted interviews, selecting candidates, then that report should include, firstly, the criteria by which the applicants were shortlisted, the names of the persons shortlisted, and the qualifications of experience of those so recommended for appointment. Now, the purpose there, so if we could just go back, the purpose there is that obviously a committee would consist of 11, 12, or maybe more in cases, ad hoc committees members who would have then scrutinized and selected the candidates. But the other members of the House and other parties may not know, they may not be privy in a sense to those discussions. So it's important that a House is fully informed of any of the steps taken and the considerations of a committee when it does select or recommend candidates. So those are the sort of views that we are suggesting. And again, if the committee agrees, if the Rules Committee agrees, we can obviously develop more technical actual drafts of rules. The next item that the Commission spoke about was this issue of the Oversight Committee over the Presidency, which is vote 1. We've just there provided some of the constitutional principles that would apply, as well as the rules in respect of how committees are established, and say that the practice is currently for the Assembly to create a portfolio committee to see each national department. And on the subject, I would also like to just mention again, and Mr. Singh also noted it, that the committee has received correspondence from the IFP, EFF, and ATM. And in the case of the IFP, this was last year, which promoted the idea of a committee to oversee the presidency. So in considering the question, and this was again, it's something that occurred in the last meeting of the subcommittee, it was agreed that the budget office should prepare a brief in order to understand how vote 1 was currently being scrutinized and what lacunas may exist. And I would like to ask the budget office to present their brief, as I said, after I've concluded. The last point which I wanted to make is to do with the recommendations about the appointment of committee chairpersons. The Constitution, of course, entrenches majority rule, but also safeguards multi-party democracy. The rule, in terms of the rules, each committee must elect one of its members as chairperson. Most assembly committees have, over time, been chaired by a member of the majority party, with the exception of SCOPA. SCOPA is, of course, and members will know that by convention, and I must say by convention, in other words, it's not a rule, chaired by an opposition member. So the Commission suggested that more parliamentary committees should be chaired by members of the opposition. Now, in our view, this is something which the rules do not currently prescribe or detail. It's something which we don't think the current regime, the current practices are illegal in any way or form. Now, to change the approach could be done either by way of rules, regulating rules, or it could be a question of political consensus, a political decision that's taken perhaps at the start of every parliament. So it could be detailed in the rules. That might make it a very sort of inflexible arrangement. Or it could be a question of political consultation and agreement. So those are the two, if you like, broad possibilities about how such a thing could be tackled. So we do think that the Rules Committee should consider the principles involved in this matter, and then whether it's desirable to have rules of this kind or not at all. So these, Chairperson, these are our recommendations and proposals. In summary, we think that the subcommittee should consider first whether legal reform of any kind may be necessary, and if so, how this could be pursued. Bearing in mind that this would be more of a medium-term intervention, and the fact that the rules could, of course, be developed in the interim. Then we would also say that that members should consider each of the recommendations we've made now and decide which could be carried forward. That is to say that the subcommittee doesn't take decisions. These decisions would then have to be answered by the Rules Committee. But once the Rules Committee has pronounced itself on each issue, the subcommittee could then draft rules on that basis. I just also wanted to say that the Rules Committee should also bear in mind that some of the proposals that are being made here will have implications, of course, for the administration and the capacity in Parliament. And so that one would need to look at these recommendations also in the context of other proposals made by the Commission to do with Parliament's budget and capacity and so on. So these things are interlinked, even though we're looking at the rules and the administration is looking at that side of the Commission. These things are, of course, interlinked. So thank you, members. I'd like to then hand over to the Budget Office, but I would ask also whether the Secretary to the National Assembly would have any comments or add anything. Chairperson, if you agree, then after that we can go to the Budget Office. Yeah, thank you, ma'am.
Thank you very much, Paran. I just want to hear from the members if we want to deal with the Judicial Commission of Inquiry's recommendations before we go to that of the Budget Office, the presentation by the Budget Office. Honorable Janji.
Well, Chair, I would, because of its nature of overlapping, that we have that presented because it will be difficult to just focus on these when what comes out of that also overlaps with some of the issues, so that we have everything put on the table and then we get into a discussion instead of doing it piecemeal.
Okay, thank you very much. Honorable Kwahobe.
I agree, Chair. Thanks.
Oh, okay, thanks. Mr. Klaso, do you have some additions on the presentation by Paran before we move to the Budget Office?
No, ma'am. I just agree that we must listen to the Budget Office. I'm happy with the position. Thank you.
All right, over to them then.
Mr. Janchi from the PBO will present. We're just then uploading we're getting the presentation that they have to make onto the screen. Thank you.
Okay, thanks, Paran.
Did you say Mr. Jan?
Did I say Mr. Janchi?
Dr. Jankis. Dr.
Yeah.
Jankis.
Yeah, sorry about that.
That's an imitation
Not
of Janchi. That's fine.
I apologize.
Not our Janchi, who's not a doctor yet. But getting there.
Yeah.
Good morning. Thank you so much. Good morning, Chairperson. Good morning, honorable members. Thank you so much for the opportunities that you gave us in this regard to share our input in our initial input with the subcommittee. Thank you so much. I'm with my team on the platform as well, whom really worked so hard to help us with the brief. I noted the concern around time. So I've made some assumptions, and also I'm telling myself here, I've made assumptions that given that the brief is with the members, I'll just focus on specific areas of the brief so that I can allow the committee to also engage further in regards to some of the matters. I would like to be given opportunity to share. I don't think my screen I can share at the stage. Let me see. Yeah, I can share. I can share. All right. This one. I don't know if members can see that one.
Yes, we can see. You may proceed.
Thanks so much. I think I'm sharing the wrong one. Okay. This. Excellent. Thank you so much. I'll just quickly go through the. Okay, this is an outline of the presentation. I think what I'll do, Chair members, I'll look at the introduction and just jump straight into performance information and look at the other matters. I'll skip the background and governance matters, which I would make assumption that members already clued up some of these areas. I think the issue I want to emphasize that this brief is a response to the request on part of the subcommittee for advice regarding oversight over the vote one, which is the presidency. The subcommittee has requested that the PBO identify whether or not aspects of the vote one are being correctly overseen by the executive structure in the legislature, and if such gaps currently exist, how then could they be closed? I think we also want to emphasize to give a context in how we've gotten to the draft brief at this stage. Really, we relied a lot on the work that we've done previously in the office under the medium-term strategic framework or NDP and the budget programs related to that. We also looked at some of the work we tried doing at the request of the committees around the economic recovery plan in 2021. We'll also look at the literature around some of the oversight processes, the reports from the AG, and so many other reports from the president itself. But also we had look at some of the Zondo Commission's matters, which I won't spend much time because I understand the committee has already been engaged on these matters. The office has asked for more time and resources to conduct comprehensive research analysis in this regard. This brief may thus be treated as an initial draft, being that more work will be required to complete this request in particular. The office identified lessons from other valuable international experience when providing a legislative oversight over somewhat unique role retained by the Office of the Presidency. So in our analysis, look at the president is to facilitate a common program towards achievement of electoral mandates and the enhancement of integrity. And we'll look at those aspects as I noted earlier in the presentation. I'll just quickly jump to the performance information because that also helped us to have more discussion around how we see the functions and how some of the areas would be linked to the realization of medium-term strategic framework, which is linked quite with the National Development Plan. You see that the table we have in the brief does indeed shows the linkage between the priorities within the midterm strategic framework. Specifically, those are specific 162, which are quite linked to the presidency itself. The presidents also indicate that the president reports quarterly on implementation of the 2022-2024 legislative program, the leader of government business in Parliament. The presidency received a total, when you look at the last year's budget allocations, to be noted that because of course this brief was done within the previous financial year, and we're in the new financial year now, we note that the allocation was that amount 614 million in the budget, which a large chunk of it is really indeed around the administration function within the more secretariat role within the office of the presidency. In terms of the economic classifications, the presidency is estimated to spend 61%, 62%, 62.1% of total budget on the COE. And over the MTF period, the activities of the presidency will focus on leading and supporting implementation of these key priority areas, economic recovery plan, and national coronavirus command council, and also operationalization of the e-cabinet system in part as well. Some of the key areas that are highlighted as some of the midterm areas of priorities in the presidency. It's clear that the presidency can and does play an important role in leading and coordinating the functions of the state. And clearly over the medium term, a budget has been allocated within the presidency for vote above the strategic areas as we noted there. Parliament oversight process requires the president, deputy president, to attend questions and answer sessions in both houses to really respond and answer some of the questions around these progress in these areas. I think the two slides, I will look at the responsibility of the president in terms of the program as how this has been made and the monitoring and evaluation around that. We have a table in the brief which actually spelled it out quite specifically. There's a program 1 administration, which will strengthen the implementation of a strategic program of political principles by providing technical and support on the ongoing basis through those mechanisms of exercising political oversight of the implementation of the government policies and programs, leading integrated planning and policy coherence in government to advance socio-economic transformation, inclusion, supporting the execution of the deputy presidents and ministers' programs, supporting interventions of the participation engagements aimed at enhancing public accountability and integrated communications, accelerate service delivery and economic development and monitoring infrastructure projects and so many other matters, including the social cohesion that is being promoted. The program 2, its title executive support, is to strengthen technical support provided to the president and our political principals in the presidency by participating in cabinet structures on ongoing basis, implement the recommendations of the evaluations of coordination structures to improve systems of governance and compliance with forums with a cabinet of forums, South African DGs, and over the medium term. Then the last program is around policy and research services, which really to enhance governance, state capacity, and service delivery over the medium term, which looks at the formulation of policy proposals independently from other functions of government, offering alternative policy recommendations, contributing to the setting of strategic agenda for the forum of the South African DGs, and so many other structures, which very clearly shows some of the greatest work that goes in there. And each and every program, it does have budget allocation of the medium term. You see that, as I mentioned earlier, the chunk of it really is around the secretariat role, around the administration functions but also the other two areas also do have, other programs do have budget allocation over the medium term. I won't spend more time here. I think I spent a little bit time here around the oversight, which is a major role that we're requested to advise on. The set of key performance indicators we vote on mainly indicates that the president produced several reports on the performance in terms of the mandate, progress on outputs that are required to make impact on priorities in terms of the MTSF, requires interrogation of these reports in analysis, which are not published. These reports are not published, therefore unavailable to the leader of business leader of government-based to monitor and the implementation of the legislative programs of the presidency. On several occasions, we have received requests from the Finance and Appropriations Committees to, for example, provide an update on the progress on the ERRP, which is almost impossible, as I noted that the reports are not public without having access to this report on the progress holistically. This is, again, when you look at page 10 of the brief, we did try to sketch out how the ERRP was spelled out, or how it's put out in our brief then, which does show that some aspect of the ERRP spent outside the public PFMA, which in a way would obviously make it a bit more difficult for Parliament's oversight, in particular, looking at those areas there. But I think the sketch figure 1 on the page 10 does try to provide some high level in that regard. It's important, really, analysis also to Parliament that the executive produce quality annual performance plans of which the indicators are measurable, relevant, and that systems are in place to measure the performance on these indicators. And I think our previous analysis and some of the analysis has shown that in many instances, the indicators to measure the performance of implementation of the MTSF, for example, are not always included in the annual performance plans. We have saw a scale of report, which just shows how much some of these APPs don't necessarily take into account the MTSF priorities in terms of how we're going to measure the success of some of these programs. We have further identified omissions of strategic indicators where departments have identified the needs in environment, communities, and economic without developing indicators to track the improvement of the situation over time. And really that would make it difficult for oversight purposes in particular. So this is just build up to show, not necessarily specifically to the presidency, but building up to say, then in this regard, the presidency is to ensure that the department's tabling of these APPs are in quality in the sense that it can provide this information as it's helpful to oversight of various parliament committees. The presidency also to report Parliament if APPs are not complied in terms of the guidelines, as we emphasize the importance of having clear measurable indicators which can allow assessment or tracking of the progress in realizing the National Development Plan or MTSF aspirations or targets thereof. And in our really initial thinking and analysis, we do note that it is unclear whether or not the current mechanisms we have in Parliament can provide a real opportunity for members of Parliament to pursue a regular request oversight with regard to specific performance and financial information commitments made within these programs or within the vote itself. The experience of other budget votes is that accounting officers are required to produce specific performances and financial reports on a regular basis for accountability purposes. According to the reports of the AG as well, you see that it does confirm that the presidency's accounting officer did indeed produce regular reports and performance information, financial information with regards to the priorities that are set out over time. The question is whether, in our analysis, the question that we pose is whether not having an oversight mechanisms according to all the presidency denies Parliament's access to these reports and prevents members of Parliament's engagement in the President's accounting officer. Alternatively, some of the thinking we pick up earlier on it could be determined whether or not other mechanisms can, within the structure, can be used by the Parliament to receive such regular briefings or to account by account officer for specific performances and financial activities within the presidency. And I think this is also inference we're making here that, in particular, we look at those three priority areas: ERP, coronavirus, and e-government. Our analysis to say that might have set expectations that there will be some form of accountability, or accounting officer will report on the progress of the budget used to realize those priorities in particular. We did even try to compare with other jurisdictions, as we mentioned. In a brief, members will note that in many jurisdictions, the plenary chambers or National Assembly or equivalent structure remains a key forum for parliamentary oversight of the executive. Classic tools like your parliamentary questions and debate are used to hold government accountable when you compare what we do in other countries. The frequency of these sessions varies from country to country. There's an example there. In other countries, question times takes place during the most settings of the House, where the questions can be asked to the various members of the executive, including the presidency. We looked at on another literature. The report shows that oral questions are also common, where plenary sessions are broadcasted live to the general populations. Oral questions can be confrontational, we've seen, and very controversial in some of the examples cited out in the literature. But also, Chair, the converse is also true that written questions are a core parliamentary activity in a number of countries, but are used marginally or not at all in some of the countries, due in part the lengthy time it takes to receive a response and allow for follow-up questions with regards to written questions in time. So it's one of the tools used in many instances, but the debates within the literature say, how do we ensure efficiency? And I heard Perrin also touching on that issue as well. And really, in a broad sense, our initial scoping, Chair, and members and colleagues, is that various jurisdictions use permanent, struggling with this, various jurisdictions use permanent and ad hoc committees as forums of inquiry. However, there usually isn't a committee dedicated to presidency as a standalone. This is currently the same in South Africa as well, hence we are doing this presentation now. So this is really a common feature across many jurisdictions that we looked at. However, I also caution that it's important to understand this difference. We should take into account the jurisdictional context of the role of assumed or functions assumed by the Office of Presidency. We couldn't really determine at the high level as we did whether other jurisdictions, offices of presidency take on governance functions program like we've seen in South African context, where we've seen a lot of a role taken on by within the ERP, also the coordination of MTSF, infrastructure project and seminar now with the Minister of Electricity. It couldn't really compare that, have much time to do that with other jurisdictions in particular. The broad approach to executive oversight rests on assumptions that existing committees and plenary chambers are not inherently focused on the presidency, yet as a collective, they still provide oversight over the office of the presidency. In this sense, through their processes, parliaments generally have sufficient constitutional powers to remove the office holders in the executive branch, which also, in our argument, is the case in South Africa. I'll end here, Chair, but I think, Chair, I just want to highlight some of the examples. A lot of examples in the brief, but we just want to highlight one example where in the literature, where the concept of the congressional oversight is applied to prevent waste, fraud, and abuse, and protecting rights of the and civil liberties there in the U.S. situation. Congress oversight forms a key element of system of checks and balances to power among the three, to balance the balance of power among the three branches of government through the several mechanisms as noted there: hearings, investigation, consultation, and getting the reports from the presidents, giving its advice and consent for certain high-level presidential nominations, and some of the areas impeachment proceedings conducted in the House and tried in the Senate, in the House and Senate proceeding under the 25th Amendment, should the president become disabled or whatever mechanisms, senators and representations serving on the Presidential Appointment Commission and so many other mechanisms. So an example that we highlighted there. And obviously some of these mechanisms always have some of the structures with them that support them technically to provide information, which speed up the work that is done by the Congress in particular. I think I'll stop there, Chair. I won't go through the Zonal Commission section, just stop there and thank you so much for the opportunity. I think what I want to emphasize, just to say, it is not within us to recommend to the committee whether to have a committee or not, but I think we want to provide this analysis, but I still think that there's a much more work that needs to be done within this process to ensure that there's not duplication, but also ensure that proper oversight is recognized throughout government. Thank you so much, Chair, and honored members in this regard. Thank you so much.
Thank you very much, Mr. Janchis, for your presentation. It was quite a comprehensive presentation. Mr. Paso, can we take the two letters as well? Because these things are that we deal with everything at once. The two letters, the one from the EFF and the one from the ATM.
Thank you, ma'am. Perrin, could you please summarize the letters?
Yes, so if we could maybe just flight them briefly, I think that would be the best. The EFF, I stand corrected. This is from the EFF. If you could just go slide them down a bit. I'm not sure if a member of the EFF would like to introduce it. I'm not sure if they're represented here, but I think I saw.
I prefer that the letters were returned to the committee. I prefer that you present them, summarize them. Thank you.
Yes, thank you. Thank you, ma'am. So in a sense, both letters really are the same. In the case of the EFF, they indicate that they've since 2018, when the president took office, there have been a lot of activities which have been centralized, if you use that term, within the presidency. Some pre-existing, but there have been new responsibilities added. And they then list some of the functions at the presidency, some of the ministries, if you like, some of the programs, some of the functions that now currently fall within the presidency. I'm not going to list them there. If you could just go down to the next slide. So there's quite a few of them. We haven't done an analysis about exactly which of these fall within which ministry within the presidency, but the argument is that all of these now fall within the umbrella of the presidency. So then they also highlight that there's now a ministry of electricity, and they view that in terms of Rule 152 of the National Assembly, there should be basically a portfolio committee over the presidency. The Rule 152, I'll just have to check that. But in essence, that's what they are proposing, that there be a committee over the presidency. If we could maybe move to the next letter, which is the letter of the ATM, which is dated 15 February. There they set out the constitutional background, oversight responsibilities of Parliament, as well as the functions of the executive, being the head of the executive, and his constitutional responsibilities. They also then talk about the macro structure of the national government, which again falls within the president is ultimately responsible for the national government. They also mention the reorganization of the executive, both in a general sense, but also in the case of the presidency itself. And again, they essentially argue that there needs to be a specific dedicated committee, a portfolio committee over the presidency. If you could just go down to the next slide, please, the next page. Again, they talk about some of the some of the functions that now fall within the presidency, some of them pre-existing, but some new ministries. And that some of these do not fit naturally within any of the other portfolios. and therefore there needs to be a more centralized approach. They also note that the presidency's budget is not specifically scrutinized by a committee. And I think the PBO have also touched on some aspects that might not be specifically dealt with at the moment. And then, so they really recommend that Parliament should consider whether it would be desirable to establish a committee whose function is or includes oversight over acts or omissions by the President and the Presidency, which are not overseen by existing portfolio committees. So that is, again, the argument. I think the question would be how, if such a committee was established, and I'm just making a comment now, how it would design in such a way not to overlap with other committees, because I think as the PBO have said, some of these functions are already been overseen, so you wouldn't want a duplication, but how the design of such a committee would be really the important aspect. Thank you.
Thank you very much, Karen, for the letters, the presentation on the Judicial Commission of Inquiry, and also the presentation by Mr. Judges on the research document. Honorable members, we note the letters that were written by the EFF and the ATM. The matter of the Oversight Committee have been seized with this subcommittee for quite some time now. So can we start with our discussion? Let's start from the Judicial Commission of Inquiry recommendations, then to the PBO's presentation with regard to the Oversight Committee, as it was brought to this committee, as it was forwarded to this committee by the Speaker from the IFP. Honorable members, Honorable Singh.
Thank you very much, Honorable Chairperson, and thank you for the presentation. Insofar as the first matter is concerned, I seem to have no problem that it's a responsibility of the Joint Committee, but I would really like to speak in detail to the second matter. And also, I trust Dr. Janchich is going to be in the meeting because I have his report here with me that I printed. And I think he omitted to deal with the conclusion in his report. But I'll raise that matter when we discuss it, because there were conclusions made by the PBO which he didn't touch on. So perhaps I'll come back to that if we can deal with the first two matters, the Accountability Committee and the Accountability Committee. Thank you.
Chair, before you proceed, I had raised my hand just for procedure.
Okay.
I would suggest that I think for neatness, it might help us as Parent Mr. Handin was doing to attend item by item. Because I can already see that my interest is at the end, but it might be good that we clean up every item that has been presented without being all over the place.
All right. Thanks for that, Honorable RG. Karen?
Yes, ma'am, I can maybe just give a very then short indication of what each recommendation of the Commission was. I think there might be.
And flight it, please.
Yeah, and we can flight it as well. If I could just ask that my presentation be flighted, and I think it's on page. Sorry, if you just give us a moment to get to the presentation again. We go down. It's in page 3 or 4. Stop. No. Go up one more. So there's down. Yes, there. Stop. So those are the first 3 subjects that the Commission touched upon: House resolutions emanating from oversight activities and responses thereto, and then the others follow. But I think we can get to them when we get to them. So the first issue is to do with House resolutions, and if you could just go down the slides. So that talks about legal reform. I don't know if we want to discuss that first, the possibility of what is called an Accountability Standards Act, and whether that should be taken forward by the Rules Committee, by the Joint Rules Committee now, whether it's desirable or whether we can just proceed with the rules. I think that might be what Mr. Singh was talking about. That probably is the first question the committee has to decide. Thanks.
Honorable
Sorry,
Kwahuda.
just to go back. Sorry, just go back up the slide. So if you could just go to the preceding slide.
Honorable Kwahube.
Yes. So they
on the Karen.
Yes, thanks. Sorry, if you could just go to the next slide. Yeah, so that is what a potential, and I call it the Accountability Standards Act. It could be, of course, called something entirely different, but that's what it could include. And as I said, this is something which was more of a medium-term intervention. It could take time. It could be a legacy issue for the 6th Parliament, and of course, the rules and the other issues needn't be they needn't depend on a law being developed, so they could be developed otherwise. So this is something which is a more of a long-term prospect. Thank you.
Okay, we'll take them step by step. Honorable Kwahube.
Thank you very much, Chair. I would agree with Perrin that a legislative overhaul, perhaps at this point, because of where we are in the term, might be something that we are unable to get through, because I think we probably have about 10 months left of the parliamentary year. And so my recommendation would be to, one, that the issue around the legislative overhaul on this particular issue of resolutions form part of our legacy report from the 6th Parliament onto the 7th Parliament. But then we look at how we can tighten the rules around ensuring that the resolutions are implemented as they should. That would be my recommendation for the first one. Thanks.
Thank you very much, Honorable Coops.
Yes, Chair. On this one, I think one is also in support of the NA table recommendation, but I think more broadly, I think we must, and I will make this point even later. We must welcome and acknowledge the recommendations of the Judicial Commission. But there has to be a context as we do that, because there are clearly 3 arms of the state that we have in this country. And it's going to be important that we respect that in everything else that we do. So where possible, we need to look into those recommendations of the Judicial Commission as to whether they are in line with that kind of a doctrine and understanding. And where there's some overlap or overreach, we must be in a position to do that, because the legislature can never do that to the executive or the judiciary. But at this stage, I would be more in support of tightening and amending the rules, because which is in the purview of the legislature and the National Assembly. Even if we are to look later into the issue of the legislation, I want to plant the seed now that it would be an undesirable intervention to make, even at whatever stage that will consider that. So firmly, I want to support the NA table recommendation, but to say we have the rules, we can always look at amending or tightening those rules. Let me pause there, Chair.
Thank you very much, Honorable RD. Honorable Papo.
I endorse what Member Janji said, particularly the principle of separation of powers. No arm of state can recommend to another arm on how it should manage its internal arrangements. Legislature cannot do so to the executive and to the judiciary. All of us are bound by the Constitution and the laws of the Republic. But there's something called internal arrangements. How, for example, we cannot be told, form a committee like this one, that should be decided by the arm of the state, because on how other arms operate, that they decide internally, as long as what they do is in line with the constitution and the rules. So for me, that's a principle we must agree on. Otherwise, we can run into problems of overreach, one arm overreaching. For example, asking the president whether he thinks there should be a portfolio committee in the legislature, it's incorrect, because the president cannot, for example, tell a legislature on how it should run its affairs. So I think for me, at the principled level, whatever issue we're going to approach, it should be anchored on that principled approach. Otherwise, we will be doing a disservice to a constitutional democracy we have in South Africa. So that applies to all the recommendations which are there in relation to what should actually happen internally. But then you can amend the rules to actually ensure that the strength and members themselves take their responsibility. And whereas there's an oversight model, which we have to implement fully in the in the NA and the NCOP in terms of how we do oversight, a very systematic scientific model, which was adopted by the legislative sector, which will help us to strengthen oversight overall, so that we don't do piecemeal ad hoc approach to oversight. It has to be a scientific process as stipulated in the well-written oversight model of the sector. Thanks.
Thank you very much, Honorable Papo. Honorable Swing.
No, thank you, Chair. I agree with my colleagues that we have to come up with a scientific method of dealing with this. And certainly the judiciary cannot prescribe to us as the legislature, but I would support these recommendations as a way forward in us taking note of what has arisen in that report, the State Capture Commission report. I mean, that's as much as we could do and act on it as the legislature, which I think we are doing if we look at the recommendation in this particular proposal that's been put to us by the table. Thank you.
Thank you very much, Honorable Singh. Honorable Lisoma.
Chair, thank you very much. Let me say, without wasting time, that I have been covered by the previous speakers. Thank you so much for the opportunity.
Thank you very much, Honorable Soma. Honorable Zungula.
Thank you, Chair. I want to come in, Chair, and perhaps state my understanding. Perhaps the committee can somewhat correct me if I've got a wrong understanding. Firstly, that this report emanates from a commission that was looking into the issues of state capture, etc. So some of the loopholes that were identified affected Parliament, or they stem from Parliament when it comes to its oversight mechanisms. Now, the report is detailing the recommendations, which are not binding, but a mere recommendations to say, as Parliament will from time to time consider methods as to how it will improve its oversight mechanisms, perhaps these are the elements it could consider. So I would not view it as a binding recommendation, or view it as an instruction from another arm of state to the legislature as to how it should do its work. Rather, I would view it as a mere recommendation to say, this is how Parliament, these are the few issues that Parliament can reconsider. In light of the recommendations, the way I view it, Chair, there's a lot of recommendations there. Parliament, in its own right, can decide that this particular recommendation, we've considered it and we think it is the best, and we can proceed with it. This particular one, we do not believe it is the best course of action. Therefore, there is no blanket approach whereby all recommendations will be accepted or all recommendations will be rejected. It's just a matter of the Parliament or the Committee of Parliament will decide on what is best for Parliament. So I wanted to make that input, Chair. Thank you.
Thank you, Honorable Zungula. I see the hand of Honorable Lesoma and Papo. And Honorable Janju, order.
Chair, thank you very much. One was not going to raise their hand, but probably you will guide us based on the comments now made by Honorable Zungula. I thought, Honorable Janji, and you took that counsel very serious to say that let's segment and be specific so that we don't go all over. And I thought we are still on the right track, that we are applying our mind on this one, the next one, and all those things, without saying that the judiciary, they were wrong. But of course, they don't understand. They might have limitations in terms of appreciation and understanding the workings of Parliament and various committees and legislations that support us. And hence, they made that recommendation. I thought on this one, Chair, we are fine. But Honorable Zungula's comment is a generic one, which is not specific to this one. But we are applying our minds, segmenting the issues that has been raised by the Commission, and we're doing exactly that. But I hope he's not managing to confuse me, because I don't want to be confused. Thank you very much, Chair.
Honorable Lisoma, you are quite correct. We agreed that we'll take them step by step, the recommendations step by step. That is what we are doing. Honorable Janji?
No, Chair, in that case, Chair, I would support that we move to the next item, because certainly from where I'm sitting, we're here to engage with these recommendations. And the assumption is that these recommendations would have been based on particular evidence. They're not just recommendations made to us, because we're going to engage with them based on facts and evidence, and not just accepting because it comes from a commission. So when we do that one by one, I think we'll be able to demonstrate that we acknowledge and accept this. But in our view on this particular issue, based on this evidence and our own practice, this is what is happening. So I want for us to do that, Chair, in terms of dealing with them one by one, and so that we don't waste any time.
Thank you very much, Honorable Janji. Honorable Kwahube?
I'm in agreement, Chair, that I think we should go one by one. I mean, I think perhaps if we want to make, as Honorable Janji did at the beginning of his remarks, make sort of concluding remarks, we maybe do it at the end. And then we do it, as you had suggested, systemically on the recommendations, each one. Thanks.
Thank you very much. Now we are on executive attendance. Honorable members. We take them one by one.
Sorry, Chairperson, I'm not sure if we concluded fully this issue of House resolutions. Maybe I'm mistaken. I know we were talking about possible legal reform, but the question of House resolutions is not necessarily a question of legal reform. It could be something for the rules as well. But if members are in agreement with the proposals around monitoring House resolutions and the obligations of the executive, then of course we can go to the next issue, which is executive attendance. Thanks.
That is the understanding, Parent, that we strengthen our rules.
Okay, thank you, ma'am.
Yes.
That's good. So
Honorable Papo, your hand is up.
I second the recommendations, because the recommendations are simply saying our resolutions must also work on the principle, the SMART principles. You can't make a recommendation which has got financial implications and you have not checked whether it will be funded or not. So I think that those recommendations basically say whatever recommendations we resolve in the House must be based on the SMART principles. Monitoring should also be there. So I think with that, it's actually better. I remember in the legislature of Gauteng, that issue came up in the third term, that you can't make recommendations which are not based on the SMART principles. But some of the recommendations of NA, of many of the are not having costs and so on them. So I think the issue of just ensuring that there's tight monitoring and quarterly reporting and departments accounting, and including the resolutions of the House in their quarterly reports, it will help us to actually keep a close eye on decisions which are taken by the House. I'm not sure whether we go to the executive attendance, but I just wanted to comment on that one. I think the approach of the recommendations will actually help us. Thanks.
Thank you very much, Honorable Papo. The general agreement is that we agree with the recommendation of the NA table on this one, that we also strengthen our rules. There should be no financial attachment to any decision that we take. Thank you very much. Can we move to the next one?
Yes, thank you, Chair. If we could just, yeah, there we go. That's the right slide. So the Commission made a general comment that, based on some of its hearings, that in their view, the executive had not always attended Parliament and specifically committees when they should have done. And they really recommended that there be consequences for such conduct. Now, in our sense, there is already a law to compel persons to appear before Parliament, the Powers and Privileges Act and the Constitution. So we were not certain whether there needs to be more another law, more legislative reform to add to that. But we do think that that the rules there could be an intermediary step. In other words, before you get to powers and privileges, before you get to legal sanctions and so on, committees could request the Speaker to intervene with the LAGB to really insist, if you like, that a minister then appear when a minister or deputy minister appear when the committee is requested that specifically. So what we're really suggesting is that we're not certain there needs to be a legal reform in this area, but there could be a rule that creates an intermediary step where if a minister or deputy minister doesn't appear, the Speaker could then intervene with the LAGB. And then obviously, depending on what happens thereafter, then more sort of legal sanctions could be pursued. So that's the principle that we are suggesting. I don't know if Mr. Castle also has a comment on that. Thanks.
Thank you, Perrin. Honorable members. Honorable Papo.
I think we ourselves, even before the end of the commission, strengthen the rules. You remember, members, we sat in the rules subcommittee, we strengthened the rules, and then the issue of public sanction was introduced. The deputy president himself said that this issue should be taken up very, very seriously so that we end the term on the good note. Member Kwahube requested the Speaker to follow up with the leader of government business. He said it yesterday on this very issue so that there's a clear understanding by the leader of government business of the rules dispensation on matters of questions, on matters of appearance. But we also cannot have a situation where a committee thinks that each time it meets, there must be a minister. It's another problem because committees must also meet without ministers and DGs. It must also do its own work, evaluation without that. And also ensuring that we don't schedule meetings on days of cabinet and subcommittees. And when deputy ministers come, we say, no, it can't be. There has to also be, we must be better organized ourselves because some committees have a view that if there's no minister, the committee cannot meet, which then surprises me whether the committee does not have its own program of oversight, following up and so on, planning. So I think there has to be a balance, but we have taken measures. We just need to enforce them, those measures now, because they only came into effect only from last year. And then the effects of them started to be shown this year with the public reprimand on questions. But on the appearances, I don't think we have to introduce other measures. We just need to tighten coordination and ensure that on key areas, I mean, obviously the budget, the APPs, the annual report, the quarterly reports, that's where you expect the ministry. And the ministry, in my understanding, is the minister and the deputy minister. And there should be that tightness in terms of coordinating that. But I think ourselves, we've taken up this matter even before the report. We felt it was very important, this issue of accountability be strengthened. Thanks.
Thank you very much, Honorable Papo. Honorable Kwahube.
Thanks, Chair. Look, I mean, I think on this one, I think the recommendation here is not perhaps what Honorable Papa was suggesting, that committees can't meet without ministers. Of course, I think they've got their own programs, but I think that this is trying to remedy is a situation where committees are unable to get ministers or their deputies who are able to adequately cover for them coming to the House or to committee meetings to account. And that is incredibly important. And quite frankly, we've seen a regression of that over the past 3 years. I agree with Perrin that perhaps a new piece of legislation is not necessary, considering the fact that there's the Powers and Privileges Act, which does say that this is how you can sanction ministers who do not adhere to a summons by Parliament. But I also agree that there should be an intermediary intervention. But Perrin, where I would disagree is in your recommendation, or in the table's recommendation, you state that a committee should raise an issue of non-attendance of the minister or the deputy minister with the speaker or the LOGB. Now, I would like to state that I think it should be a member and not just a committee, because at the end of the day, I mean, if a minister or a deputy minister is not in attendance and the committee is not in consensus about the fact that that minister needs to be in attendance, a member of Parliament should be well within their rights to be able to approach the speaker and state that, look, I mean, there have been issues in this committee where the minister or the ministry is not attending to account. And so that would be my only amendment, that it shouldn't just be confined to a committee, because we also know that there are minority reports in committees. And so I would urge that it should be any eligible member of Parliament who wants to raise the matter. Thanks, Chair.
Thank you, Honorable Kwahube. Honorable Lisoma.
Thank you very much, Honorable Chair, and also align with myself with what has been recommended and also amplified by Honorable Papo. Chair, let's agree that, but also because it's factual, that the report was written and submitted to us at a certain date. And between now and the submission of the report, there's a lot that has been happening in Parliament in terms of also doing our own introspection in terms of how do we execute the oversight and making sure that the executive accounts to Parliament. That's one, Chair. Hence, then, Honorable Papo's point that in terms of the attendance of ministers in the House, it has been raised with the Speaker, and appropriately the Speaker has responded to that. And I don't see any gap thus far, which equally goes with the written questions that would have asked by honorable members to the executive. Secondly, Chair, we must also be responsible and assist committees. That there is a timetable or a diary of the sittings of the cabinet, which has been circulated to us. Probably we might also ask the leader of government business to recirculate to us, with an understanding that is not going to change. Two is that from our side as members at various portfolio committees now, in terms of appearance in committees, is that we do submit before the end of any given quarter the program of the incoming quarter. But the problem, Chair, must be told that sometimes it's our own making, that we change the program without also going back to the actual program that would have submitted and change it among ourselves at the committee level for whatever material conditions that we find ourselves and reasons that warrants that. So I'm saying I agree with what has been presented by Mr. Parran as well as what Mr. Papo have raised based on that. Secondly, Chair, in committees, there are those items that you know that definitely this one, the owner or the leader politically of the department must be there. Quarterly reports, budget presentation, yearly plans, and all those things. But there are other issues that are only for committee to deal with. And sometimes we create an impression that each and every committee sitting, the minister must appear, even there's nothing that wants her to him or her to respond to. But even then, in some instances, the minister will delegate that to the deputy minister, accompanied by the DGs in some instances. And I think committees must also accept that the minister, deputy ministers are equally in the absence of the minister, having delegated by the minister to appear before the committee. And I think the way we might, and I think I don't see anyone disagreeing with that, other than that, we would not necessarily want to sensationalize what we are addressing. But let's say we'll monitor that. If need arises, then it will come back to the committee. But at the current moment, we are on the right track, and and also we are demonstrating that the recommendations of the commission, also we are applying our minds, but also taking the material conditions as to what we have done from what has been happening previously. With the Chair, I'll say I agree with the recommendations have been elaborated by Honorable Papo. Thank you very much, Chair.
Thank you very much, Honorable Isoma. Honorable Singh.
No, thank you very much, Chair. I think, what Honorable Papo said is correct. We've been kind of overtaken by events on this matter. And I think all of us appreciated the fact that the Honorable Speaker did what she did in Parliament. I remember it was Honorable Jordan Lewis that brought this matter. He sat on a subcommittee and we put through interventions. I don't think there's need for any legislative processes that we need to follow, but probably as a rules subcommittee to recommend to the rules committee that we take note of this and we understand that there are mechanisms in place. I also believe that in the first instance, the matter should be discussed in a committee and the committee chair should be writing in to indicate whether or not a member of the executive, has not been forthcoming. We've had that, that, and it's not only members, it's members of the ruling party as chairpersons on behalf of the committees that have written to the speaker, and rightly so. So I think in the first instance, let's get that process done by the committee. But if the committee is not taking it up, then possibly a member could write in and then say, well, I brought this matter to the attention of the committee. So-and-so minister seems to be a radical, perpetual absentee from our meetings, and please assist in that regard. But I think we are all on the same page in terms of, accountability and the processes that are underway at the moment. Thanks.
Thank you very much, Honorable Singh. Honorable members, we are in agreement that there are processes in place, the mechanism in place that are currently taking place even before this recommendation came through. So indeed, committee chairpersons must write to the speaker if they have challenges with regard to accountability from the members of the executive. But one thing that we must bear in mind is that we cannot have members of the executive every day, every week in committees. They must do their job. We must do our oversight as well. Thank you very much. Can we now move on to the next item? Parran?
Yes, thank you, ma'am. It's to do with the appointment of office bearers and state entities. If that's the right slide. Sorry. Yes. So there, obviously the National Assembly has a role to play in the appointments of many office bearers and chapter 9s and other entities as well. And the commission felt that some of these processes weren't consistent, as in some cases there wasn't enough transparency, there wasn't enough public involvement. And so it really endorsed some principles about how Parliament could go about this activity. If you go to the next page, I think the next slide. Okay, yeah, so these are, in this case, the committee again spoke about a possible legal reform. So you talk about some kind of act which would then provide for a sort of an umbrella omnibus act about how Parliament should go about appointing each of these office bearers. Again, we think that an act is probably not, well, it's certainly not within the ambit of the Subcommittee on Rules. It's something that should be taken up maybe again by the Rules Committee and possibly the Joint Rules Committee. But again, we think that there could be rules in the interim to tighten up some of these processes. So if you go to the next page, the next slide, these are some of the rules that we are suggesting in terms of, and let me say this is, if you think of the South African Human Rights Commission, this is just an example, there's an act which governs how the Human Rights Commissioners are appointed. So any rules would be subject to this relevant acts. So these rules would be general, but they wouldn't, of course, supersede any specific provisions in any act. So this would just be a general approach that committees would take. So it's got to do with the application period. It's got to do with the fact that the public can be invited to comment on people shortlisted, and that tries to speak to this issue of public involvement. And this question, obviously, that the Assembly must also vet candidates before they recommend. So that really is the essence of what we're suggesting here, that a law maybe in the future, but the rules could be tweaked to provide a kind of general guidance, let's call it that, to committees when they undertake this function. Thanks.
Thank you, Perrin. Honorable members, Honorable Kwahube.
Thanks, Chair. Again, here I would definitely support the tightening of our rules. Perrin in his presentation did put down some generic sort of I suppose criteria which can be used to be incorporated into the rules, you know, around fit for purpose, the transparency around a merit-based system, the transparency around qualifications and the like. I would like to add an additional criteria there where it is incumbent on the particular office bearer to be independent, that we should rule out people who have political affiliation, particularly things like Chapter 9 institutions. And I think in the rules, we should make it explicit. I don't think we should leave it to chance. And so I think in the tightening of our rules, I think political affiliation where an office bearer is expected to be an independent entity should be explicitly ruled out by the rules of the National Assembly. Thank you.
Thank you very much, Honorable Kwahube. Honorable Lisoma.
Thank you very much, Honorable Chair. Probably let me just quickly dispose or engage on the latter part of Honorable Kwahube. Recently, which is the bill that it's from the Minister of Labour that deals with that part, there's already a legislation that is underway in terms of public servants or even office bearers that they shouldn't be active politically, because sometimes I might be known that I'm a politician because I'm active, but how do I then establish that somebody who's not publicly probably posed as a pressure group or an analyst, but whereas has got a political party view, ideology, and vote for that political party? And I'm saying there's a legislation that addresses that, and it will be duplication. Of course, it's the issue of timing of the report as well. But I think we must also acknowledge that there's an existing bill that is in the NCOP which addresses that. Two, Chair. I will say that probably we need to agree and accept that there are existing practices that are in place. And of course, depending on that appointment, because some of the appointments, like Chapter 9, it's very explicit in terms of the committee must agree of a person which is fit and proper. And then having the committee agreed on that, then they continue doing their work, but also they will to have agreed in terms of the milestones as well as the activities as what has to happen. And I think then for me, I think we are on the right track in Parliament. And of course, there are those also those office bearers that are not necessarily Chapter 9. Probably we need to say even Chapter 9 and Chapter 10, because Public Service Commission also falls under that. And of course, we have been backing with the issue that there must be uniformity in terms of best so-called inverted commas best practices. The committees of the 7th Parliament, what they have copycat from or borrowing from is the previous 5th Parliament, the process of appointing the public protector, which was very elaborate, where it also allows the public to engage and comment and all those things. And my understanding is that that is what is happening now. But if it's not, then which means it needs to be looked at and be tightened where applicable, be a uniformity. So all in one, Chair, I'm saying that there are established practice by all committees, not almost all or many committees in processing these appointments of office bearers and their entities, which is at many will be your Chapter 9 and 10. However, the Commission recommends that there must be more rules, must reflect to the rules of Parliament and processes, which we are fine with that. However, the challenges would always arises, but the spirit of intention of the recommendations is what is likely exist in Parliament. So my initial point. So I would like to say it firmly to say that, or probably before I use we, I would not agree with a further legislative route that needs to be taken to balance the establishment of that evidence needs to be brought forward. But however, I've just made a reference to the NCOP bill for public hearings for around this matter, which then we are covered on that one. And of course, there will be continuous shortcomings in the entire cycle, but the committees do have a responsibility and procedures that needs to be in place can be undertaken if evidence is based that there's this appointment that was done which was not in line with perceived agreed established practices that all of us we understood are in place. Thank you very much, Chair.
Thank you, Honorable Soma. Honorable RD.
No, Chair. Thank you, Chair. I was hoping that we'll be very short on this one and put it aside. It's quite straightforward. And I think we should all agree. I think Honorable Soma makes the point that we already have got existing practices by many committees in terms of how to deal with this. I think we should not opening the door of at this level entering into the criteria because each of these sectors would have even from an advert as it is put up, the criteria would be clear as to who qualifies, who's needed for this and so on. I think we should leave it at that point if we have to strengthen those criteria, because you don't have a one-size-fits-all criteria in all of this. There will be different requirements. Some would need for example, for the public protector, if you are 10 years as an MP or more, like Honorable Narang Singh, he qualifies to be applying for the public protector. Whether he comes from the IFB, that's immaterial. But there will be different requirements per sector, and so I'm saying if you open that door, you would not be able to close it. We must be able to confine ourselves to what is needed in that particular sector and the criteria that can be put. The last point, Chair, which is something I think I need to raise so that it doesn't affect us going into the other areas. We've got to disabuse of this notion. So, and I don't know why, the Judicial Commission seems to be thinking that legislating issues is a panacea of all ills in the legislature. They're just throwing legislation for everything. And it's not helpful, because sometimes the problem here is not legislation. Sometimes the problem is not even rules. Sometimes the problem has to do with whether there's leadership that can prevail on this particular issue. To just throw in is like a template recommendation. There's a template recommendation about in order to improve this, you need this legislation. It's not helpful in the manner. And so I think I want to add my voice to those that says, I don't think we should go that route. I think they've not really problematized the issue or even scrutinized as to what the real gaps and issues are. And instead of just putting the standing recommendation of legislation, even where it doesn't fit. So I think we should be saying something and engage on that issue, that it's not helpful, that for every gap that they saw, the solution to it is legislation. So I thought I must just make that point as a general point across many other points, but it keeps coming. Thank you, Chair.
Thank you, Honorable Artie. Honorable Papo.
Chair, before Honorable Papo, in case he comments on what I've said, in terms of the example that I made, if that's a Municipal Structures Act, I was just making a side issue on that one. It's got nothing to do with this one, so it's separate. I thought I just need to clarify, but I was saying, proving a point that not everything needs to be legislated, Chair. Thank you.
Okay, it's okay. Honorable Papo.
I think the reason why there was an amendment to the Municipal Structures Act is because local government sphere has no separation of powers. It's only in metros where the separation of powers are now being implemented, but it's not like at the provincial and national level. That's why where you find mixture of officials who become chairs of committees and so on. That dispensation is because the local government sphere, it's a separate sphere with its own law. So we cannot use that example there for Chapter 9 institutions and other chapters which are in the Constitution. The reality is that majority of people will have political affiliation at one time or another. Some people joined the struggle when they were 14, 15. And then after 94, they went into business. Others went to become professionals and other things. Now, you can't say that political affiliation must be a basis. Yes, there are certain positions. You can't be an office bearer of a political party. You can be a member. And if you are a member, you intend to apply, you resign from that political party. So this notion that people are apolitical and therefore, and usually it applies to members of the governing party who are a majority. You'll find supporters of the governing party in almost every sector of society. Some of them would have been even soldiers of MK and things like that. So this notion that political affiliation is a problem. The issue is whether people meet the criteria. You can't use political affiliation because there have been instances where people left newsrooms and joined a political party and became MPs. Now, I'm going to say all those things they were writing were actually on the mandate of the political party they now represent. So I think we must be very careful. So remember, Janji is right. Justice and Correctional Services applies a very, very good criteria when they do it. We should use that example of correctional justice and correction. They even put 3 months to have finished the process. And I think all committees must use that in terms of the timelines and so on. But the criteria differ in terms of the requirements per institution. We're going to have a problem with not getting people if we're going to say we look at the history of somebody. It's as if you are punished for having been in the struggle. And therefore, you cannot be part of any institution which you fought and even got tortured in jail for. And therefore, you cannot participate in a democracy because you have happened to have been a guerrilla or somebody who did something. So I just think this political affiliation must be explained. But if what member Kwahubek said, I don't think we will accept it, because committees are now using criteria, and even some of the people who come from opposition parties have links who are appointed. Must they be prejudiced? The issue is whether they are active members and they are executive and so on. That's the issue, not history and affiliation. I think it will create a lot of problems in terms of getting people to apply for its competence, fit for purpose, qualifications which are required, measuredness, all those things, ability to take decisions, firm even against where you come from historically and so on. So it's not the criteria, but I don't think we can use that thing of a political affiliation as if we've got all these people who just woke up in 1994 without political views, without involvement. That cannot be. And usually it's used against people who have an association with the governing party, and it's not going to happen. I don't think it will be accepted, that view.
Thank you, Honorable Papo. Honorable Kwahube, you want to come back?
Just on a separate matter, Chair, I think my point about political office bearers who are meant to be independent was well made right at the beginning. But the point I just wanted to perhaps respond to is Honorable Gianki's the point about not every problem requires a legislative solution. And of course, while that might be the case, I think it's still a worthy exercise, Chair, as we are doing now, to go through each and every one of the recommendations and still weigh up whether or not legislative amendments in the future are something that is desirable, or in the interim, we can tighten the rules. I don't think that we should necessarily throw the baby with the bathwater at this point. Thanks.
Thank you very much, honorable members. Indeed, we have processes in place that are currently happening. Interviews are conducted publicly in our parliament, and also the public is invited to comment. Then the issue of political affiliation is neither here nor there, because no one is neutral in our society. People are linked to one or the other political party. So let's not dwell into that, honorable members. So the agreement is that we can then strengthen our rules or improve on the current mechanisms that we are using, because currently we are using the very same mechanism that everything is done publicly. The public is also invited to comment. Can we now move on to the next item?
Thank you, Chairperson. Yes, so just quickly, there are 2 items left. The one is the question of the presidency. The other is the appointment of committee chairpersons. And in both cases, the rules are the law in the case of the presidency really say that it's up to Parliament's discretion, really, whether you need, to what extent you need a specific committee. That you need to conduct oversight and you need to have mechanisms is certain. But how that is actually arranged is a question for Parliament to answer. So maybe I should just leave it there for the presidency. I think members know the background. Obviously, there has been correspondence and so on about this. So I think maybe if I could leave that there, and parties or members could raise their points of view. Thanks.
Honorable members, here we are. Your input on these ones. Honorable Kwahube.
Thanks, Chair. I think having listened to the Parliamentary Budget Office and the table staff, basically essentially indicating that the decision lies within this structure and obviously broadly the rules committee. I think it is absolutely critical, because if we are to look at what the recommendations of the reports that we are looking into have said, and if we are really serious about using the powers that is vested in us to be able to strengthen accountability, then I think that we should proceed with this matter. I think this matter has been within the subcommittee for a long time. And in fact, the last time that the issue around the presidency or the committee on vote one came around, it was then the issue was whether or not we should see if there are any lacuna. The reality is that the budget office has not indicated that there isn't any lacuna. They've said that, well, the decision is yours. And my view is that we've got to take a united view to the Rules Committee to say that let us institute a vote one committee. And what this will do is that it will cover some of the particular ministers who are not covered currently within the governance cluster or any other existing committees. This is over and above the 600 million rand that is spent by the presidency, and whether or not we are able to have access to those documents of how the money is spent. But there's political oversight which must be exercised. There's a Ministry of Electricity. There are at least about 4 or 5 ministers within the presidency who don't all neatly fall within existing portfolio committees. In addition to that, as we've always argued, that the presenting vote one by the president in Parliament does not in any way constitute a consistent oversight over the presidency, which is becoming a very big entity in our government. And so my view would be this matter is firmly within our ambit of decision. And so we should make the decision, and we should make the decision to recommend to the Rules Committee to have the committee. Thank you.
Thank you, Honorable Kwahube. Honorable Papo.
Reading the report of the Parliamentary Budget Office, firstly requesting a little bit more time. At the end, they are raising a number of, they are saying there's nowhere in the world where there's a specific committee, even if they still have to do more research, which focuses on the presidency, but they give examples of Great Britain, where there's a joint committee and so on. I would recommend that we then go a little bit deeper, grant them that space to do more work, but also ourselves, the speaker, through the speaker basically look at the recommendations, the suggestions they are making there, so that we go deeper. For example, are the examples given at the end in that report taking into consideration the type of constitution that country has and ours? What gets discussed in that forum where, for example, the Prime Minister goes? There is the blanket, because already we have got measures. So we a little bit go deeper. We don't say we reject. I mean, our view was that we were not convinced in the last meeting. Hence, we requested the Parliamentary Budget Office to do. But I think we need to little bit give them a bit more space. But the speaker and the team in the speaker goes a little bit deeper so that we get details. Because we must compare apples with apples, because our system is not a clear Westminster system. It has got elements of the UK, Canada, Australia, the African experience, and so on. So I'm just saying that we need to just go a little bit deeper in those suggestions which they actually make, what we could do. We can't make a blanket recommendation that we must have a committee. I don't think that will help, because they have requested a little bit more time. But I myself, when I read the 15-page report, I want the details of how those things are done. We already have committees of chairs here in the. Could that be the one where those ministers go in and report? So we need a bit of detail in terms of the mechanisms they are recommending, and check other jurisdictions also, and that will also help us to prepare for whatever report we do. We can then decide whether we implement it before the end of term, or we actually implement it in the 7th Parliament. So I'm not talking about it being implemented, but I just need a bit more detail, because a 15-page report on such a matter is not something we can just then decide to make a general recommendation. Because if that is the case, I don't think we're going to agree. But without saying there are no merits in terms of some of the suggestions, but I think the report does not give us a sense of apples with apples in terms of our frameworks of the frameworks of different countries. So my stance has changed based on the report, but I think there must be a little bit more work done by the PBO, supported by the presiding officers of the National Assembly, to get details on all the issues and check whether we cannot expand to other jurisdictions in various continents, maybe our continent, Latin America, and so on, and check the comparative, expand on the comparative examples, particularly examples of countries which have got similar constitution with us. As I say, our constitutional dispensation is a hybrid. Thanks.
Thank you very much, Honorable Papo. Honorable Singh.
No, thank you very much, Honorable Chairperson. Thank you for the reports that we've received. I beg to differ with Honorable Papo. I think that the report by the research by the PBO is very precise, very accurate, and that's why earlier on, Honorable Chairperson, I said that I think Dr. Janchis has not completed his report in terms of presenting it to us. Because if you read his report, right in the end, in the conclusion, there are conclusions made there. And I don't want to read the conclusion because, the conclusion is quite direct to say Parliament must now decide on this, and that it is in the interest of democracy and the system of checks and balances that Parliament must decide whether a vote one should be established. Now, I can't see the reason for us kicking for touch here. This is a question about good governance. This issue is not about what other countries do and what other countries don't do. It's a South African constitution, which is heralded by the world for its content. Yes, we copied from other democracies in looking at what they had in their own constitution, but it is our constitution. And our constitution, which we hold up with pride, says that there should be oversight over all committees that are established in Parliament. Now, vote one is a committee. It's not the presidency. We don't want the president to come and report here. The accounting officer is obliged to come and report. And what our colleague Janchi, Honorable Janchi, said at the last meeting, let's get the research office to see whether there are possible areas which are not being oversighted by and presented by the ministers in the presidency. And they've come up quite clearly in this report to say so. So if we say in principle that we are not going to establish an oversight committee, then we are missing out a large portion of a budget allocated, through Parliament that is not being accounted for by anybody or by that particular accounting officer. So, I really think that we must not, delay with this matter. But even if we in principle say, yes, we need to establish a committee that oversees all the budget that is expended or provided for by Treasury, and we can work out the mechanism of how that is done. But the principle of establishing the vote, I believe, is not something that we can delay any longer. And there's ample evidence in this report, in this 15-page report, and anywhere else in our constitution for the establishment of such committee. And the last point I want to make, Chairperson, is unlike the other recommendations and considerations that came through from the State Capture Commission report. This is not although it arose in that report, it is a matter that we've been seized with now for 5, 6, 7 years. You know, we had another president before, and then there was the I think unintended thought that perhaps we want the president to come and report. We're going to put our current president and future presidents in a very invidious position when we start debating their votes and say, but tell us about this amount in this budget. Tell us about the other amount, when the accounting officer himself or herself has not presented justification for that amount. So, you know, we can get very trivial in the debates and start asking, you know, very detailed questions on why 50 rand is allocated here or 50 million there and not there. Those portions which other ministers can't account for. So it is a reasonable request. It has been kicked for touch from pillar to post for the last 5 or 6 years. I don't think this must be a political decision. It must be a decision based on good governance, and it must be a decision based on what our constitution says to us must be done. And I think if we have to take this in any other forum, I mean, it's without doubt, it'll be said that Parliament, you have to do this. And I don't think we should be obliged by any other arm of government to do what we can do ourselves in the interest of good governance and accountability. Thank you. So I will propose that this subcommittee agrees in principle that the Vote 1 committee be established, and we can work out the mechanics of how it's established. And don't look at UK or any other country around the world, what they do and what they don't do. Thank you.
Thank you, Honorable Singh. Honorable Zungula.
Thank you, Chair. I want to align with Honorable Singh in his later statement when he's saying, in principle, this committee or subcommittee must agree that a committee must be set up for Vote 1. Now, when it comes to the modalities and the mechanisms that are used to make sure that it is an effective committee, that we can discuss at a later stage. But on a principle level, that number one, the Constitution mandates Parliament to actually ensure that all executive organs of state are accountable to it. In other words, there is no executive action that is without scrutiny, or there's no executive action that has not been, that there's no oversight that has been done by Parliament on it. Now, in light of the Vote 1, whereby we cannot, confidently say that the Vote 1 has been or is accounted for fully. Now, I would also say, Chair, with the discussions that we have here, yes, we do understand that there are questions to the President, there are debates, there are other mechanisms of ensuring that there is oversight over the President. However, in light of good governance, particularly when it comes to now strengthening the oversight of the executive, it is in that spirit, Chair, I would say that we need to proceed with the setting up of the, we need to take a principled decision that a committee must be set up. And then at a later stage, we then proceed with the modalities. Also taking from the input by Honorable Papa, where he's talking about how it would work. I think that is a decision that could be taken at a later stage to say, based on the lessons that are learned from other countries, other parliaments, this is how they are doing things. Now, from us as the South African Parliament, this is what we are thinking will work best for us. But at a principle level, in line with the mandate and what the Constitution requires of Parliament, there should be no executive action that is without scrutiny. There should be no executive action that Parliament is not playing an oversight role on. Now, with Vote 1, it is clear that there are gaps. So this committee has to bridge that gap. Thank you.
Thank you, Honorable Zungula. Honorable Lisoma.
Thank you very much, Honorable Chair and colleagues. And now probably the heading that says that oversight over presidency, it's misplaced. It should say oversight over vote one. Because I can hear the comrade, I think it's comrade Singh that has been explicit on that, because I was going to say that there is no committee under presidency that doesn't report to the portfolio committee, other than the electricity, which is a program that is under the president. The rest they are. Having said that, Chair, I think we must also try to be honest to ourselves. I take note, Honorable Singh's point that it has been going for the last 6 years or so. But we must accept that the 6th administration is paying attention in engaging on this matter, and it must be appreciated. Let alone that also in the state of, in the commissions, there is a report, there is a section that talks to that. And I think it would be unfair to behave as if there's nothing that is being done. But however, Chair, I wonder what's the rush and the impatient and the agitation that is being demonstrated on this one. Because the PPO, when he made his presentation, notwithstanding that, the mere fact that he didn't go to the recommendations, my understanding was that this is a preliminary presentation or report that he was making. He's still further going to do and deep down in terms of other areas, if there are any gaps, and also areas that we need to pay attention to. As Chair, I would agree and support Honorable Papo's point to say that even ourselves, we need also to satisfy ourselves that there are other lessons that we can borrow from other countries. Equally, on the same breath that Honorable Singh has raised, that the constitution that we have is not only tailored and brewed in South Africa, but it was borrowing other lessons from other countries, let alone that no other country has got such a constitution. And no other country that wants to borrow our constitution in terms of empowering its own constitution. But I'll leave that one because it might be a political issue. But coming back to the issue at hand here, is to say that let it be on the table, because it's not fair to say we agree or disagree. And we some of us, I for one, as the ANC member, we haven't reached that stage where we can say we disagree or agree. We are saying that let's engage and let's have through the Speaker's office, to borrow from other countries' lessons in terms of how they handle this office in particular, as well, and allow the PPO also to further, when they are ready through your good self, Chair, they will indicate when this subcommittee can sit and look at that report. And that sitting, Chair, I'll request that be a sitting meeting whereby nobody will be rushing somewhere for other meetings or for the flight. Thank you very much, Chair.
Thank you very much, Honorable Lisoma. Honorable Janchi.
Chair, I want to make further contributions in addition to what all colleagues have said on this matter. And maybe from the onset because we're also, this is a point where we consider both the letters of the EFF and ATM. I want to make the point that having looked at those letters, having listened to presentations from the IFP many months ago and the PBO, the two letters are not really helpful in assisting us and reaching this discussion. And so whatever that we do should not really be based on those two letters, because this has been a process in motion. The second point I want to make is to say to Honorable Singh, I'm growing into confidence as a member of this subcommittee that I think we're traveling a journey that there are issues that are emerging. I wouldn't want him to throw hands and in saying we've reached the end of this, because correctly he quotes what we did last time. We asked that a dedicated and proper work be done by the PBO and research in assisting us to come to a decision. Because if we had a decision before that, because what we must now avoid is a briefcase decision. Now, what do I mean by that? A briefcase decision is that there's always been a decision that we had in our minds, and that asking the PBO to do this research was a mere formality because we had this decision. Either way, I don't think that is going to be helpful. Because when you take an approach of a briefcase decision, it means you don't listen to evidence being presented to you on a particular matter. Because in Afrikaans, yeah, the oogklappies, you have these blinkers about this issue. You are dead set on something. Because Honorable Singh correctly quotes what we did. We said, when we pause on the other time, let's get more work done to assist us to understand this animal that we're dealing with. And I think what has been presented so far is beginning to open our eyes in terms of where the gaps are, where the progress is, or where practice is even beyond South Africa. I certainly wouldn't agree with Honorable Singh that let's not look at any international experience. I don't think we can operate in that way. We're not an isolated country that does its own things. Even our own constitution is a comparative study of a number of other constitutions that we did. And so I don't think it would be helpful to do that. Before I go to the issues, in terms of what emerges from the PBO and the recommendations that are here, by the time when we asked them to do this research, we knew that there are areas of oversight and accountability that already exist within this area. Whether that has to do with the debate itself of vote one, where it's an opportunity for that oversight, whether it's about these quarterly sessions of quarterly questions to the president, taking 3 hours more than any other minister would do, let alone the State of the Nation address, and the fact that, as Honorable Lesoma is saying, you have no less than 4 different departments under the presidents as we speak that account and have got standing portfolio committees in that regard. The role of the leader of the government business, including ministerial statements. But what is coming out of here after asking the PBO to do the work, they are coming back and they say to us, let me start at the end. Correctly, they say the decision either way is going to be our decision, not even this subcommittee, but the rules committee decision, because we can never put pressure on them to make that kind of a recommendation to us. What they have to do is to put on the table the tools for us to come to that decision. And so I don't expect them at any point to say, we recommend that you put up this committee or you don't put up this committee. I am of the view, Chair, that perhaps it will be a good thing that we get into. I'm not tiring of this process, Honorable Singh. We get into, because I can see that we're getting somewhere with the work that we're doing. And perhaps we can start the process of delivering a gift, perhaps to the 7th Parliament, around the kind of things that we can do. The PBO says itself that we're presenting this to you, but this is an initial draft. we need more time. You can't just ignore that and say, no, we want a decision now. So why did you ask them in the first place to do this? Because it then renders the action we did before as a mockery, that we're not genuine about what we're doing. Goes back to my a briefcase kind of a decision. So they're making that point, and I want to respect that. I think that's closer to what Honorable Papo is saying. We can then agree with them to say, so how much more time do you need to complete what you have not completed, which is an initial draft? And what would that take? Does this take a further desktop work that must be done, and for how long that must be? Or are we saying ourselves as members of this subcommittee, so that we're not only dependent on that kind of research work? Is there also from our side, I heard issues about the UK and other countries. I would take an approach that says, what are the other relevant countries, even if we're to take Honorable Singh as members of this rules committee, as part of enriching this process, even if we're to take a study tour or a trip in the identified countries to satisfy ourselves about this issue, I think we should do that to help us get to that point. So I'm aligning myself, Chair, that I want to appreciate what has been presented. Clearly from the report indicates where the gaps are. I don't know if those 1 or 2 gaps that have been indicated, whether it is the reconstruction, economic reconstruction program and the others, was the bulk of the gaps seem to fall into administration kind of program or work. I don't know the other 2, whether they qualify and constitute as things stand now, an establishment of the committee. Because if it is about the economic recovery program, I don't know whether you need a committee for that. But Honorable Singh seems to be coming also with a different dimension and angle, which I seem to connect with, that says, and I don't know if was those 2 letters of the ATM and EFF don't speak to that, to say it is about now the accounting officer. It's not about the president. So that's a different take. But where I stand, Chair, is that we almost at the point where we're able to conclude the evidence that we sought from the PBO and further research, in order for us to go to the Rules Committee and say, we think that this is the route we take. From this meeting, I don't think we accept if we just want to say we've been too long on this and therefore let's take a decision regardless. I don't think that will be of any great help. So I still want to support the views that says, let's complete what we're doing and give more time, and we can agree on how much time that is to conclude the work. Certainly not from what we have had today. Thank you.
Thank you, Honorable RT. Honorable Kwahube, your second bite, followed by Honorable Singh.
Thank you very much, Chair. Thank you, Chair. Chair, I want to vehemently disagree with Honorable Gang. I think now we are firmly on the ground of filibustering, because ultimately, as the PBO has said, the decision is ours to make. In fact, even before we had commissioned the work of the PBO, we had in ourselves discussed the matter at length, and we had seen some of the merits. And of course, some people didn't see the merits. But I'd also want to remind the committee that it's also incumbent on us we know what the problems and the unique problems that we have are. We've all read all 4 volumes of the Commission's report. At what point are we going to at some point say, well, we've got to introspect and we've got to fix something? If we keep kicking the can down the road to either the 7th Parliament or to a study tour or to other comparative studies, at what point are we going to actually do the work of tightening our own rules to make sure that we don't have the kind of slipping through of executive oversight that we've seen over the years? And I really think that, whether or not the design of the committee itself, or whether or not we want to say this is not just about the budget, but it's also about executive oversight, whether this is just about vote one, regardless of any of that, there's a principled decision to be taken here. And we can either agree to filibuster the thing and until, the term ends, and then that's what the subcommittee decides to do. But my view is that we've got enough information before us to make a decision. It's either we want to or we don't. And I think this is just simply an issue of delaying tactics. Thanks, Chair.
Honorable members, before the other members come in, let me just remind all of us that this is a subcommittee where we engage each other and we are not taking any decisions. So the report to the Rules Committee will have all the views of the members of this committee. Thank you very much. I just want us to be clear on that one, that we can discuss all day, but we are not going to take a decision as this committee, as the subcommittee. Thank you very much, Honorable Zungula. It's Honorable Singh, thank you.
No, thank you, Chair. Chair, I really appreciate the last comment you made, because I felt that perhaps we are going to, put a resolution before us to say what the subcommittee decided. It's quite clear that we are not agreeing. While I respect the views of all the members, we're not going to agree whether we should establish or not establish. Some of us are firmly saying that we must set in motion the establishment of a vote one, and I accept that it should not be called presidency, vote one, and that is based on this report. I would like to hear Dr. Janchis to tell us what else can they come up with and how long do they need to convince us that we should be oversighting all money allocated to every single executive department in the country. So, if they can tell us like we need to do A, B, and C, and we need a week or we need 2 weeks, perhaps that will convince me to say at the Rules Committee, well, we've made a lot of progress, and I appreciate what Honorable Lesoma is saying. It's only in the 6th Parliament that we are taking this matter so seriously, but you will realize that for a number of meetings, this matter was a below the line item, until I raised it specifically with the Speaker, and it was the Speaker who said, bring this above line and start discussing. And I appreciate the role that you are playing, Chairperson, in ensuring that we have this kind of discussion on this matter. And in terms of looking elsewhere, we don't have to go outside of our country to know that the executive head's department, not the executive head, the executive head's department, which in other areas of South Africa we call the premiers, all have an oversight committee on that vote one, all of them without exception. And I've been around for many years to know that. So why should it be different at our sphere of government? That's the question I'm asking myself. But I need to be convinced that we need more time. Why do we need more time? And then that convincing must come from the PBO, because I believe the PBO have gone into a lot of detail here. They've spoken about what the Auditor General requires of us. They've spoken about what the Constitution requires of us. And it's all is left for the Rules Committee to make sure that we implement what is in the Constitution. It is a constitutional imperative. And I would like to leave this meeting knowing that, yes, we've discussed this matter. There was no agreement. Let's take it to the Rules Committee. If we want to have a debate in the Rules Committee, we will be prepared for that full debate. in the Rules Committee. If the Budget Office can come up with anything before the 25th, that'll be great, because there's a Rules Committee schedule. But certainly, Honorable Chairperson, I don't feel good that we are not trying to come up with something decisive on this matter, understanding the politics of it, but from the point of good governance. I think for the last 8 or 10 years or more, we've been saying, as soon as we start the debate on vote 1, that unfortunately, Mr. President Zuma or Mr. President Ramaphosa or Mr. President Motlanthe, we cannot interrogate you to the extent that we would like to, because a lot of interrogation should have happened with your accounting officer. So I don't know how we're going to deal with that, but Chair, I really feel that we have sufficient information before us to take this matter forward. And it's not an appeal, because next year you might have another president. We don't know, from another political party. Then what are we going to say? Let's not hold that department accountable. We can't say that. Let us put in rules and laws for the future, not for the current situation that we find ourselves. That's my last appeal on this matter, but I'll see how you summarize it, Honorable Chairperson. Thank you.
Thank you very much, Honorable Singh. Honorable Zungula.
Thank you, Chair. Chair, I want to, taking from what Honorable Singh has just raised now, particularly that at a provincial government level, there is mechanisms to ensure full accountability of vote 1. And I would, Chair, maybe go back to my initial statement to say, with the mandate of Parliament that is saying, the mandate of Parliament is to ensure that all executive action is accounted for, or Parliament plays an oversight role over all actions of the executive. Now, what the report has clearly stated, there is a gap, and that is not informed, for example, by the letters that were written by the EFF or the ATM, but it is a gap that has been identified by the report, that there is a gap whereby there are elements in terms of executive action that are not, there's no provision for effective oversight and accountability. So in my view, Chair, I think we need to take a principled decision to say Parliament, or this current Parliament, needs to close that gap. Now, when it comes to the modalities, like Honorable Jantje has alluded, that it could be given as a gift to the next coming Parliament. But that is not a decision, Chair, that I think we should take in the sense that we are going to work preempting that this will only be finalized in the next term. Rather, if we do what is required of us now, or what the rules of Parliament require now, it is based on that pace, based on determining what will work for Parliament in terms of the rules, whether there needs to be further studies or further research that is done, exactly what will be done, how will the committee function, how to avoid the committee duplicating some of the work. That comes after the decision has been taken that indeed there is an interest. Sorry, indeed there must be a principle that we need to close that gap. Now, time allocated or time taken to actually finalize the matter, we don't know. We can't preempt. It could take a month, it could take 2 months, but we must not take a decision that this must only be finalized, or this must be, we must work towards giving it to the next Parliament. But Chair, on a principle level, when you look at what is the mandate of Parliament in terms of the Constitution, what does the Constitution require of Parliament? Based on the report that has been presented, here are the gaps. Therefore, the only logical thing to do, it is for the Rules Committee to close the gap by establishing a committee. Now, the name of the committee, whether it's vote 1, the presidency, it is something that could be carefully refined to make sure that, people accountable in terms of the wording, but the principle of closing the gap is taken. The principle of ensuring that there is no executive action that is not without Parliament scrutiny, that is dealt with. So I would move, Chair, that we take a principled decision, or we take a principled view, and then we work out the modalities later. But in our view, we must have the view that we want to close the gap that has been identified, and we want Parliament to be fully compliant to the Constitution with regards to what the Constitution requires of Parliament in relation to executive oversight. I thank you.
Thank you, Honorable Zungula. Honorable Lisoma.
Thank you very much, Honorable Chair. Yeah, no, just to say that I taking from Honorable Singh's points. One is that it will go before the Rules Committee. You are going to summarize, Chair. I'm not summarizing, but I'm engaging. That members of the ANC, now I'm going to say that instead of a subcommittee, where we are, not where, we are of a view that says that we need more time as to allow the PPO's office to do some work and come with a final report in terms of the options. And that's what they said. His first line, that's what he said. And I think we must respect that, because if then we had a briefcase decision, we shouldn't have asked him to do any work. That's one. But why we asked him, we wanted to be scientifically influenced about the evidence before us that either way, we are in the right path. Two, Chair. Honorable Singh, which now is bringing another dimension, making the provincial setup. For me, I would say that we still need to have information that tells us that, I would say KZN, that's how they do it. Western Cape, that's how they do it in terms of the actual activities. Because the blanket one also, for me, even Honorable Zungula also appreciated now to say that now Honorable Singh is saying that the provinces are like that, which means he didn't know, but I'm not speaking for himself. But for me, I've never done that study, and I will need for me to be fruitfully engaged in this issue to have that information per province, not a blanket statement that says that. Then for me, Chair, I will suggest that we have made our inputs and the rationale of more time. Also the speaker also to give us, or even this committee, through our research unit, to look at the possible lookalike countries that we can go to and borrow some lessons from them and say this is what. And we are saying that we are not going to be forced to say yes or no. We appreciate the agency probably, but there must be thorough work, because we are not going to make a decision for the current administration, but we are saying that the country, South Africa, the Republic of South Africa, must live with that time to come as well. Thank you very much, Chair.
Thank you very much, Honorable Lisoma. Honorable Papo, you'll be the last one on this.
I don't want to make
item.
an input, but I just wanted to say that the difference between the national sphere and the provincial sphere is that premiers are members of the legislatures. The president resigns as a member of parliament. So we must not also use examples which some of them don't fit. President is not a member of the National Assembly. Premiers are members of legislatures. That is why what member Lusoma said about a blow-by-blow assessment of what all the legislatures are doing. It's very important, and I'm interested to know what Western Cape does. Thanks.
Thank you very much, Honorable Papo, for clarifying that. Honorable members, I've been listening to all your arguments in this regard. I just want to emphasize the point that as Parliament, we always embark on a study tour to learn the best practices on countries with the same systems that we are using as a country. So there's nothing wrong with doing that, and that on its own empowers Parliament and make sure that we do right by the people of this country. Then the second point is that on the report of the PBO, on that report, they've indicated that one, they need more time and more resources to conduct a comprehensive study or research and analysis. This was a little bit rushed report, which is, for me, it's a preliminary report. So we cannot ignore that as this subcommittee. Lastly, I want to say that, honorable members, we know that as this subcommittee, we don't take decisions. We process matters. A report will be written to the Rules Committee, to the Speaker, which will be presented to the Rules Committee. The Rules Committee is the one that will take a decision on these matters. So I want to close this matter in that order. We all want accountability. We all want to do our oversight work. We all want to enhance it, but we are not taking any decision as this committee, as this subcommittee. Perrin, can we now move on to the last item on the agenda?
Thank you, ma'am. Yes, so the last item concerns the appointment of committee chairpersons. And in this respect, the State Capture Commission was quite brief in terms of its recommendations. And it said it's recommended that Parliament should consider whether more representatives of opposition parties should be appointed as chairs of portfolio committees, I should say. And there, legally speaking, there's no obligation at the moment to do that. So in other words, it is in fact a question of political agreement. And that's why, if you look, for example, at Scopa now, why we have a member of the opposition party chairing Scopa. So it comes down to really a political decision about whether, in principle, for example, the Rules Committee supports the view and that at the beginning, say, of every parliament, there must be discussions with a view to appointing more chairs. But the other side, the other possibility is rules. But rules are very difficult in this case, difficult to draft because political situations change, circumstances change. So it's difficult to say how many chairs, how many committees should be chaired by an opposition party or which opposition party, because obviously there's quite a number. So a rule would be quite difficult to develop. But those are the possibilities. Thank you.
Thank you very much, Mr. Handik, on this one. Honorable Lisoma. Honorable Lisoma, is this a legacy hand? Or you want to speak on this matter?
No, for now, Chair, it's a legacy hand. I didn't see that my hand is still up because I was just still listening to Mr. Parra. Thanks.
Oh, okay, thank you very much. Honorable Papo.
I don't think we should accept that recommendation unless we don't have a coalition government at national level. The issue of Scopa is just a practice, it's not a law or in the rules. And therefore, I don't think that recommendation actually it will be correct unless there's a coalition government, people can share committees and things like that. That one, obviously, there's no, it's a non-starter, that recommendation. Thanks.
Thank you very much, Honorable Papo. Honorable Kwahube.
Thank you, Chairperson. I agree with the table staff about legislative changes, and that this would be a political agreement. But where I disagree with them in its recommendations is to simply say, well, this will be up to whatever agreement any political party may have with another. Because I think once again, and I think this is a similar thing to the point we discussed just before this one on the portfolio committee on vote 1, that we've got to look at why are we here? Why are we here is that Parliament has over the past decade and a half been found wanting in its ability to hold the executive to account and to do its constitutional obligations. This is why we're here. This is not just a routine check of whether our rules work or not. The reality is that we are here because Parliament has regressed and has failed in many instances. And the report that is before us has spelled out in great detail, not just to us, but to the entire country, how we have failed to do what we were meant to do. And so we are here now because of that transgression. And so we mustn't look at this through the lens of, yes, of course, these are merely recommendations, not binding. But at the end of the day, we also must take it upon ourselves to understand that there's something seriously wrong with how Parliament is doing oversight. And I think that to simply dismiss something like this and simply say it's a non-starter is not a very helpful way of going about saying, how do we fix how oversight in Parliament is done? And I think colleagues and Chair, I mean, I suppose if the mood of the meeting is that of saying this is a non-starter, this mustn't even be considered, then I suppose, you know, numbers will dictate what is agreed to or not in the Rules Committee. But I just want to make the reminder that we are not here just by advent of time. It's not because the term is wrapping up, we're making a review of the past term. We have failed. And if we don't correct, we are going to go down as the Parliament that sat with a report that says your processes do not work, fix them. And we elected not to fix them. And so I'm saying that if the subcommittee is saying, well, no, we're not going to even process this and go through to the Rules Committee, well, so be it. But I think that there is merit in considering how can we make sure that we put opposition chairs in particular committees. It is international best practice. Other legislatures have done it before. In provincial legislatures, it is often done. And I think it's something worth considering. Thanks.
Thanks, Honorable Kwahube. Honorable members, when you make your point, not to tie the subcommittee on it because we're still discussing this matter. Honorable Papo, is this a legacy hand?
Yes,
okay,
it is.
Honorable. Okay, thank you. Honorable RD.
No, Chair. This really should be a straightforward and simple matter. I upfront at the very beginning had indicated and alerted this committee about us being vigilant on the doctrine of separation of powers. This is one classical example, and it drives straight into that area. I think what we should say as a summary of our discussion here is that the Commission's recommendation is misplaced and misdirected completely. Their attempt was about how you achieve, I guess, robust oversight. And in their view, you can only achieve that with the appointment of chairpersons. It's misplaced, it's misdirected, and it must be said as such. We're engaging with their recommendation. If they want us to get into what it means to have an effective oversight is not about who chairs what committee. I certainly would have come from a space where I played opposition in the Western Cape. Then and now, when we drive an effective oversight, not because you from an opposition, you must go and chair a committee. The only committee even now in the Western Cape that will be chaired from opposition is that of SCOPA, same in the National Assembly. You have no other committee that gets to be chaired by any members from the minority, unless they have run out of numbers from their own members, which is by accident. the issue here, and I'll go straight to section 57 of our constitution. This is really an overreach. The commission cannot dictate to the legislature that us having gone through elections, we've been voted in, the strength of each party is recognized in the constitution. There must never be any other rule or any other suggestion to dilute that. I mean, section 57 is about internal arrangements, proceedings, and procedures of the National Assembly. Only the National Assembly must determine those internal arrangements. And that includes how you determine the control in, for example, internal, how you compose your committees, how those committees are run, who chairs those committees. The commission has no business to even recommend to us about how that must be done. It's clearly an overreach, which speaks directly to that point. And then we must say it as such that we accept that in your way of trying, because this is an indictment about both to yourself, Honorable Dlagut and Honorable Singh. It's an indictment about how the Fifth Parliament kind of ran things. But we should never be made to pay for those kind of inefficiencies and kind of failures. So I think we must indicate upfront that it is one thing, because in the sixth administration, in terms of robust oversight, it's been demonstrated. Even demonstrated as far as the last 2 weeks, for example. The Justice Committee was just recently dealing with the best walk out of prison. Across all parties were demonstrating in their articulation, in their intervention, what it means to play an oversight role. Nothing about that is about how you appoint chairpersons. It must be the prerogative given by this constitution of how that is composed in the National Assembly. And when all parties, 14 parties are there, you can never dilute the fact that the governing party had a strength based on what the voters have said. So I don't even want to go further into those issues. The point I want to make is that I don't think we should waste our time on this issue. We should report to the Rules Committee that we think that this recommendation is misdirected, is misplaced, and that if there is a request to see how we play oversight, I think we should demonstrate that it has nothing to do with appointing chairpersons from other parties and so on. As we said earlier, the scope, I think, is not even a rule. It's just a practice or convention that we decide to do. So I just want to pause there, Chair, just to indicate that I don't want us to deliberate this point any further. There is no basis for the decision of the commission to have made this point from where I'm sitting. Thank you.
Thank you very much, Honorable RD. Honorable Singh.
Thank you very much, Honorable Chairperson. I would be inclined to take a little softer view than my learned colleague on this matter, because if you look at what is before us here, I think the operative words in the last paragraph are suggested and may be served. So there's no prescription here. So I mean, it'd be no sweat of our back if we note what they've said and refer it to political principles, because at the end of the day, I believe that it's going to be a political decision. I think Honorable Papa said that as you move towards an election, then there's give and take, there's coalitions and so on and so forth. And part of this might be something that, the largest party, I'm not saying the majority party, the largest party may put on the table. So I don't think it's something that should be discounted, but just noted as a suggestion and they not being prescriptive. And then let parties decide, what they want to do moving forward. But I don't think it's something that the Rules Committee should be considering in terms of amending our rules specifically, but it must come out of a political discussion as we move forward, as work in progress. Thank you.
Thank you very much, Honorable Singh. Honorable Papo.
A legacy hand.
Honorable Lisoma. Thank you, Honorable Papo.
Thank you very much, Honorable Chair and colleagues. I think the latter part of, no, not the latter part, the points that has been advanced by Honorable Singh, then changes what I'm going to say. Just in short to say that the recommendation from the Commission is not desirable with the points that has been advanced by Honorable Janji and Papo, because we can't have a coalition of a special type. And I don't know where it's going to happen, that one, because there's no other province that our colleagues would like us to borrow from, because they must also show where they claim they are leading, that they are doing that. And this perception that your oversight capabilities are limited because you are not the chair. Even now, you are the chair, Honorable Dlagut, but you are not the one that tells us what to say. We don't react on your way forward. We engage and then you summarize our points. So there's no concrete evidence that suggests that. It's a perception and it shall remain a perception. And for me, Chair, it's not desirable, and we are not acceding to that. Thank you very much.
Thank you very much, honorable members, for your deliberations on this matter. Indeed, I want to concur with the inputs made by your good selves, Honorable Papo, Honorable Janji, Honorable Singh, and Honorable Lisoma, that indeed this is a political matter. We are not in a coalition government. We can only note this and not do anything about it. It's up to political parties what they want to do with their power. So in that note, let me take this opportunity to thank you all for your participation in this subcommittee on rules. Our report will then be taken to the Rules Committee, which will sit on Tuesday. So, honorable members, thank you very much. I know in this committee we will not agree because this is where we process matters. Matters will then be taken to the Rules Committee. And where there's a need for further work to be done, it will be done as such. Thank you very much, honorable members. Thanks to our political support staff and also the NA table, Mr. Kaso and your team. Thank you very much. And also to the director of the PBO for your attendance in this meeting. The meeting stands adjourned.
Thank you, Chairperson. Thank you, colleagues.
Thank you.
Sorry, give me 1 second. Let me